not here. Thank
Sorry.
you. That's okay. He's not here to give legal advice. So Brian is here to present our presentation. If there are any questions, please put them in the chat. We also have about 10 or 15 minutes at the end of the program to ask any questions. And then we also can provide you, as I mentioned, with a copy of this PowerPoint. You can also find it on YouTube. You can also go to pmconline.org and see previous recordings on all of our 11 topics that we do. And then we can also provide you with Brian's information afterwards. Thank you very much. And I'd like to turn it over to Brian.
Thank you, Michelle. I just have one question. I'm not sure how I'm coming up on the screen. Whether this where's the camera?
You're coming up now that you're speaking.
Oh, it's always okay.
Yeah,
The owl follows you.
Owl is the camera?
Yeah.
As well.
Yes.
So am I big enough or am I a little tiny person in that room?
You're there with Pam. It's perfect.
Okay, good. All right. So thank you. And for everyone, there's 11 online. And we have 2, 4, 6, 8, 9, 10 of us here, including us. So that's a nice turnout. My name is Brian Gordon. I'm a wills, trust, and estate attorney. The first thing I wanted to say is just hats off to the Pennsylvania's for Modern Courts and letting people know how important the judiciary is. In the past, when I was, sort of coming along, growing up, and then as an adult, it was really like pulling teeth to get people to come to judicial elections. And as many of us have learned, it turns out that the judicial elections are, in my view, the most important elections that we have. Because it turns out that the courts are who enforces the rules of democracy. In the absence of courts and quality people who committed democracy, we won't have democracy. So it's that serious. So please, I'm sure you show up for every election, you get the word out, it's vital. And thank you for Pennsylvania for Modern Courts for doing that work. So we're going to talk about the principal assets of an estate plan, which is a will. I call it, there are going to be different categories, but it's essentially a will. Let me scroll down.
Oh, go ahead.
Right. Yeah.
If you want me to advance, I'll advance it for you.
Okay, hang on just a second. I'm gonna go right there. There we go. So there's a will, there's we'll talk about a limited power of attorney, a financial power of attorney, a healthcare power of attorney, something called a living will, and a HIPAA authorization. So these are kind of complicated, and in most lawyers have sort of assembled these in 3 different documents and they group together. There's a will, there's a financial power of attorney, and then there's a medical power of attorney with HIPAA authorization and with like an advanced directive of what you want to happen with you when you can no longer communicate your wishes medically. Do you want to keep the plug in? Do you want to pull the plug out? It's the simplest formulation. What treatments do you want? Do you not want? That sort of thing. So I wanted to start with a will. Historically, a will was really important because people had most of their assets in a bank account or an investment account titled in one of 2 ways. It was either in their name or the name of themselves and a loved one, like a spouse or somebody else. These days, so a will was important because, for example, if you had investment accounts, if you were a married couple and they had investments accounts, the only way to transfer the investment accounts to the next generation is either by a will or by the intestate scheme, which is the will that's written into the statute. So it was one of 2 ways. And then along maybe in the 70s started the ERISA statute, maybe a little bit earlier, and you had things like 401k plans and you have employer savings plans, and anything savings plans, either an individual retirement account. You had a variety of accounts, and those were regulated differently. They went outside the scheme of a will, and they were pay on death to specific designated beneficiaries. So these days, you have an array of ways in which you can hold assets that are either an individual name, in joint name, or pay on death to a specific person. And it's really important that when you sit down with an attorney, or you're just on your own and you think about how do I pass assets from one generation to the next? There's always been a bunch of different ways, maybe 10, but now we have many. So for example, and this is the art of estate planning, like, some of the main ways you would transfer assets from one generation to the next is, for example, a deed. So you have a deed between husband and wife, and what you could do if you had one child and there wasn't going to be arguments, you needed to sell the property, you could have a property deeded into the name of the parent and a child. So parent dies, property immediately passes to the child by operation of law, doesn't go through the courts, you don't need a will, anything. Likewise, and these are really important tools today, you might have a joint savings account. So if you have, for example, a mom and a child, mom and daughter, dad and daughter, whoever, and those are the only two people in a small family, it may be the best way you might want to hold your assets is in a joint account. And then what happens is the first one to pass, then the property goes by operation of law to the surviving joint owner. And that's a tool of estate planning. One other tool I wanted to get you thinking about of passing assets from one generation to the next is a gift. So suppose you have these beautiful objects around your house and they're things that people care about, and you just, they're just, they mean a lot to a lot of people. And you had a grandchild who always admired a certain clock or jewelry, and you wanted to get certain pieces, certain people. One of the things you can do if it's later in life and you're really not using them yourself is you can hand them to the person, to the beneficiary. And that's a gift. A gift is a really important tool from an estate planning standpoint, because there's a certain certainty to it. You have the joy of giving it during a lifetime, and then the person has the object, and there's not a lot of fighting happens after someone passes. So those are some of those tools before we get into a will. And then the question is so we're going to talk about the will and what's the importance of a will. So the importance of a will is that even with the array of joint bank accounts and pay on death accounts, you still wind up with assets in individual name. So suppose you own assets in your own name, you own assets with your spouse, you own assets, so as your house was in joint name with a spouse and your spouse dies, that house is then going to go into your individual name. And it becomes really important. Suppose you have, suppose you have 3 children. You might want that house to be sold, have the proceeds go into an estate account, pay the taxes, the debts, the administration expenses, and then you want to distribute. You may want the proceeds of the house and the other individual accounts to be distributed equally among your 3 kids. So the first role of a will is it organizes the transfer of assets from one generation to the next. There are other tools I didn't talk about, which I can't get into all of them because this whole course in estate planning, like trusts and things like that. But the will is still a very important document because it picks up stray assets in individual name, even if you have most of your estate in retirement accounts. And it also picks up assets that might have once been a joint name. You may not even know it, and they're in your individual name. So it's still important to have a will, even if you're trying to avoid probate and you put all your assets in joint name. Okay, so you can take all these steps, but you ought to have a will. Now, what happens if you don't have a will? If you don't have a will, there is a will written into the statute. And the basic scheme of the will is that the legislature in most states tried to predict who you would want your money to go to. And there's some permutations, but under the intestate statute, means no testate, no testament, the money would go first. So if a couple had 3 kids and husband passes first, the money would go 50% to the spouse, to the wife, and 50% divided between the children. That's the net estate after paying taxes, administration expenses. So it would be, and a lot of people don't want that. A lot of people will say, well, I don't really want that because my kids are fine. I care that my spouse will be okay. I want her to have, if we don't have all the money in the world, I want her to have the assets. So most of the wills that I've seen for people with more limited estates, they look with a nuclear family, you know, with spouse and kids, is all to spouse, all to wife, or all to husband, and then distributed in equal shares to the children. Okay, so that's the other reason. It sets forth, you decide how you want things. Now, why else is the will important? Well, the next reason is you might, in almost every family, I'll say jokingly, including mine, you might have kids who are really high functioning and good with money, and kids who aren't, right? You might have kids who are just spendthrifts. You know, worst case scenario, you might have kids who are, or you might have kids who are disabled or have drug and alcohol problems. There might be a lot of reasons that you might want to trust on their will. So imagine you have 3 kids. You have, you know, child A, B, and C, and we'll take the, no offense to anyone, we'll take the middle child B, and suppose the middle child's, it could be anyone, trust me. I've seen it, that could be the oldest, could be the middle, could be the youngest. But suppose one of the children really can't handle money. Well, what you would have, or heaven forbid, if a child is in an accident or through illness becomes disabled and unable to handle money, what you could do in a will is you could provide for a trust under your will. So you could split the assets into 3 pieces and then have the piece for the disabled child or the child who can't handle money fall into a trust. And you can name someone, the person who decides how to distribute that money. And then it gets even a little bit more, there's more of a twist to it. If you have a child who might wind up on state aid, like really the child with disabilities who's on public housing and that kind of thing, you can graft on, very easily graft into a will, a Medicaid trust, and special language that pretty much gives absolute discretion to your trustee to make or not make a gift to a beneficiary, depending on other resources available, either insurance or government resources and that sort of thing. And by having that magic language in your trust, then the trust becomes it's called a third party special needs trust. Third party meaning you're giving money to your kid. It's not their own money. Special needs trust, they might have an interaction with Medicaid. And what it will do, which is really a wonderful thing, is that Medicaid pays for housing and certain benefits, but there are things it doesn't cover, right? So if you have the Medicaid language, then your trustee could buy things for a disabled child that are not covered by Medicaid, such as maybe glasses, maybe dental care, maybe whatever it is, but you can have a fund to provide for that person. That could be a spouse as well, who's disabled. So those are, and that's some more complicated Medicaid planning, but at least the rudimentary parts are there, and that's another reason to have the will. It's a really important document. The other big reason why you want a will is you could name someone to manage your estate. And this is picking an executor, also known, if there's no will, he or she would be called an administrator, and the common term is a personal representative. So just for our purposes, because I think it's a little clearer, so let's call it the executor is someone who's appointed in a will to wind down your estate. So when they say wind down, the steps are as follows. Gather in all of the assets, identify all the ones that are in your individual name, as opposed to pay on death, which are different. Bring them, liquidate them, sell the house, liquidate the accounts, put it all in one account, the estate accounts, you can eventually distribute it. You need to pay any existing bills. Maybe you want to you can negotiate the bills down, you pay the inheritance taxes, just so you know the very, very basics of that. When if a couple, the spouse has 0 tax under federal law, 0 tax under state law, so there's no tax between spouses, no inheritance taxes. But for the second spouse to die, if there are children or grandchildren, when the money goes up to parents, then the tax is 4.5%. For unmarried couples, the unmarried person's treated as a friend, and that creates tax avoidance issues. That tax is pretty heavy, it's 15%. So you have an estate of say you have an estate of God willing, $1 million, you're literally writing a check for $150,000 to the Department of Revenue. So you might want to avoid that, then it's calls for some other tax planning. So that's the basics of administration, basics of taxation. So the categories are for lineal descendants, children and grandchildren, 4.5% goes to Department of Revenue, Pennsylvania. And this is the net estate after paying the debts, after debts. A sibling is 12%, and a stranger or a friend or a significant other, no marriage, is 15%. I have a very interesting estate right now. I don't know whether to digress too far, but it's really interesting. There's a couple, and I was filling out the tax return. I was just about to ask her for a check for 15%. And I said, by the way, how long were you a couple? She said, oh, 25, 30 years. I said, well, did you ever hold yourself out to be married? She said, well, a lot of people thought we were married, right? And I started asking further. I said, did you ever exchange words of, you're the one for me? It doesn't have to be, I take it from my wife, I take it from my husband. It could be words of the present intent to be married, that this is the one. And she gave me a scenario, and I'm thinking, my God, she could save. So the estate was $600,000. So she has a potential savings of like $90,000. Just because I asked the right question. And we'll see what happens. We don't want to broadcast this. So it's very interesting stuff, sometimes. So that was an interesting case. So that's the basics of the last will and testament. It specifies how outright or in trust to whom your property will be distributed. You should name an executor who is responsible for complying with legal requirements and overseeing asset collection, paying debts and taxes, and distributing to beneficiaries. Those are the basics of it. Assemble the assets, pay the debts, pay the taxes, distribute the money out. I've had questions recently of, can't we just not sell the property and just see if the market goes up in a couple of years? Well, the law says you have to wind up an estate unless everybody agrees. You got to march toward winding up the estate. You should sell it. And when you have volatile markets and you have a down market with real estate, as an executor, you feel like you're doing a bad job, but that's the job you have to do. Everyone agrees, let's keep the house for a year and see what happens. That's fine. But if one person wants out, you got to sell. You should pre-plan your burial and not leave decisions that should.
I just want to remind, maybe you want to advance the slide.
Oh,
Sorry.
sure.
And maybe Pam can help. I'm sorry.
That's okay. No, do you want me to, how much time do I have left?
It's, you got a half an hour, so that's okay. I just don't want you to,
No,
want to make sure. Yeah, because you're going, you're mentioning other slides, so I just want to keep you on track.
Okay. There's a really great recommendation here, maintaining a list of assets, including real estate, bank accounts, brokerage accounts, insurance and annuity policies, passwords, and security questions. I want to touch on these briefly. You don't have to list these in a will. That question came up today because it says I give the residue and remainder of my estate to my two children. Do you need to list all your assets in a will? No, it's all contained in the residuary clause. So whatever in your individual name is covered. But what you should do to help the person who's trying to administer your estate is write a good list of your assets, including passwords to accounts and things like that, including your online stuff. And you want to put a 1 or 2 page memo into your estate file, both at your attorney's office and at home, to explain what you have. It's a very useful thing. Insurance and passwords, we got that. Okay, next one. All right. So next we'll talk about powers of attorney. Powers of attorney, this is the cheapest and the most important document you can have. Why is it the most important? It names a person who can act on your behalf, called an agent or an attorney in fact, if you are unable to communicate for yourself, if you're unable to manage your financial affairs. So it gives you an opportunity to name a trusted person to handle your financial affairs. In the simplest sense, is someone to keep writing checks when you cannot, you're physically or mentally unable to do so. In a broader sense, it could be someone who does estate planning for you or liquidates certain assets and then and maybe helps you move into a continuing care facility and can sign or execute all those contracts. So there are different kinds of powers of attorney. The most important one is a financial power of attorney. And this says, you know, I appoint my son, or my friend, my husband, and sometimes you have person A, and if not person A, then person B, then person C, as my agent to handle all of my financial affairs as much as I could, as if I were handling those affairs. The broadest, oftentimes they're given the broadest possible powers, but there's also something called a limited power of attorney. So I had a case where a husband and wife, the husband went back to Greece for work as a researcher, and the wife, they wanted to continue.
See that, Kev, about 10 minutes.
Okay. Anyway, I'll keep going. So there's a financial, where was I? Anyway, you have a limited power of attorney, just it can be as broad or as narrow as you want it to be. You can have a power of attorney to just govern one transaction. Okay. The healthcare power of attorney, just make sure this is financial power of attorney. There we go. Broad powers: paying bills, depositing funds, handling financial and business accounts, making gifts, employing professional help, accessing and using digital assets. You want to put, that's a paragraph which I've added about 5 years ago, like computers, cell phones, etc. You want something very clearly telling digital providers that you have full and complete access to those accounts. A limited power of attorney can be handle specific tasks on a temporary basis, such as paying bills, participating in a closing, pursuing claims and litigation, making medical decisions for surgery or minors while parents are away. Now, the durable power of attorney covers instances where you are incapacitated or mentally unable to make a sound financial decision or healthcare decision. Durable means that if you go from having capacity to incapacity, it still is legally effective. It takes effect. There's something called a springing power of attorney, which I generally try to talk people out of because the goal of a power of attorney is to stay out of courts. So a springing power of attorney takes effect only when someone's incapacitated. The whole point of a power of attorney, a financial one, is so that banks and financial institutions like Merrill Lynch or whatever will recognize you as the person in charge of the person's financial affairs. If you have a springing power of attorney, they're going to say, how do we know that the person's incapacitated? So there could be tests, and I think it winds up, they'll say, well, get a court order, and then just think of $10,000 to $20,000 down the drain. So I avoid that if possible. If you don't trust the people to be your agent, then you shouldn't have a power of attorney. It has a legal notice in the beginning of it that says what the purpose of a power of attorney is, and that it's a warning, like you are giving someone the power to sell your property from underneath you. And it's an important warning. So you want to only give your power of attorney to people who are highly trustworthy and won't put money in their pocket. As they say, if there's $1,000 on the table, you walk out the door, they can take it. You never know the kind of person that $1,000 would still be there. Let's see. There's an acknowledgement at the bottom of the power of attorney. There's an acknowledgement about having you read it. You're acknowledging the person act as an agent, and the agent has to act in accordance with the principal's reasonable expectations to the extent actually known, and otherwise the principal's best interest. The agent in the power of attorney has to act for the agent has to act for the principal, the person who's giving the power of attorney. It's for their benefit. And you have a fiduciary duty to do anything you do with those assets has to be for the benefit of the person who gave you that power in the first place. It's very hard to enforce these rights if it goes astray. So the most important decision is picking the right person in the first place. Healthcare power of attorneys are very interesting. This ensures that you will receive medical treatment you desire, avoid unwanted procedures, limit your pain, be treated with care, dignity, and respect. You appoint a healthcare proxy an agent, sometimes they're called a healthcare proxy. And either you can be temporarily.
No, that was me. Sorry,
Okay.
sorry.
So a healthcare power of attorney, the basics of this, which you need to know, this is a really great document. Hospitals are dangerous places. You appoint a power of attorney in order to protect you in the hospital and say, this is my point person. So if you're, a loving spouse or a friend, doesn't matter whether you're married, not married, you want to appoint someone who's not, who will stick up for you and try to make sure you're given the right care and can interact with the official, the doctors and nurses. So to me, that's one of the most important purposes. The other purpose is that you can express your desire for what procedures you want or don't want. Hang on a second. It's some directions to decision makers. You can express your values and philosophy about healthcare and treatment. So what I usually do, and most lawyers do, they have a healthcare power of attorney, and it's combined with a living will or an advanced healthcare directive. And it says that if you are on your last expectation of recovery, where more treatment will just prolong your dying, it gives permission to withdraw treatment that merely prolongs your dying. They're often phrased that way, or similarly, they're not all the same, but you can also make them as detailed or as basic as you want. So I usually ask the clients, so they really understand what I'm talking about. Do you want to leave the plug in or pull the plug? The default under Pennsylvania law and the law of every state is they do every procedure possible in order to revive you. But starting, I don't know, actually starting since the beginning of time, before there was advanced medical care, people, there was people wanted to be at home perhaps and not have all these procedures, and then be able to have direct a loved one to say, you know what, if I'm really on my last illness and my systems are shutting down, don't keep trying to fix those systems. Please let me go. In my own case, my mother, who lasted until 92 and a half, 2 Junes ago, we knew my brother and I had been taking her to running her to Lankenau Hospital back and forth for many years, but we knew she was coming to an end, and we had we were both her power of attorney. And in the end, it was very clear that this was her last night, and we both held her hand and told her that we loved her. And she was cared for, and she knew it, and it was, and both of us feel really good about those decisions. We think that our mom really appreciated not being rushed off to Lankenau one more time with paddles and that kind of stuff. So, this is where you can express that. Just today, if you were to contact me, I was someone brought to me from a book about dying with dignity, the most beautifully worded statement about treatments that you want or don't want and how you want to be treated at the end. These are getting increasingly sophisticated and beautifully drafted. So I just got one today. I grafted it. I took the email, put it right into their healthcare power of attorney because I never saw a more beautiful statement. So if you're interested in that, please contact me. Healthcare directives, advanced healthcare directive living will is what I was talking about. It's a set of instructions expressing your wishes for medical treatment, end of life care. There's a statutory healthcare power of attorney that says, I do want infusions. I don't want the paddles or electronic respiration. I do want this. I don't want that. I do want this and don't want that. And I wanted to tell you that if you feel really strongly about not having a certain procedure, like if you never want a pacemaker, put it down. But in general, and I've asked physicians about this, you'd rather have, the physician wants a general direction of what you want. Do you want to be kept alive, use every medical procedure, or do you want to be, to allow to have systems shut down and die quietly and perhaps with more dignity? Which is it you want? But they asked us as lawyers to give us the full toolbox and just give them general direction of what you really care about in terms of final illness. I have had people who have said, I love life, I believe in medicine and I want everything, regardless of the cost. It's another story. I even had one man who had several pensions going, and he made me write, he wanted all the procedures, unless he was in severe pain, because he wanted to be kept going, because he was still supporting his family, even if he was unconscious. Well, that was interesting. Anyway, let's see, a living will. If I have an end-stage medical condition, the living will is the end-stage medical condition. And then here you have, I especially do not want heart lung resuscitation, mechanical ventilator, kidney dialysis, surgery, chemotherapy, antibiotics. If you really care about these things, you don't want to put it in there, express your wishes. But the doctors, I've said, is just give us our toolbox and let us know what you want to do. HIPAA authorization, federal rules may cause healthcare providers to deny access to your healthcare information and participation in your care. You can have a separate form, but it's best to have it all together, in my view, so that your agents, your healthcare agents, your children, in most cases, or your dear friend, can have access to all of your medical records. And even if I have a list of, I choose person, the first person to be my, John to be my first up. To, one person, number 1, 2, 3, I always give them full access to medical records because these are your trusted people. It makes no sense not to. You don't want them, the doctors and nurses, holding that chart from you. You want to make sure they have access to it. You can use a separate authorization to get medical records. Or you can include it in your healthcare power of attorney and living will. Your HIPAA authorization. Let's see, we keep going. Resources. All right. Here's
So
some
we have a couple questions. If it's a good time, Brian.
There we go.
Okay. So one of the questions is, can we get more details on living will, like how much it might cost? A list of attorney or firm can help. Well, we have that. We can send them that resource. Can we create will by using software? So how much does it, sort of estimate on cost? And is there a software that or a platform that can help draft a will?
Yeah, so the answer is yes, so let me first go through the cost. If you go to an attorney, a suburban trust and estates attorney, a will might cost anywhere from $500 to really $500 to $5,000. I'll get into that in a second. If it's a person of modest means, I know attorneys like me would do a will for $500, which doesn't really even cover 2 hours of time, but it's more sort of like a community service. But if you have a house and middle-class estate, generally it would be about $1,500 per person for a will, power of attorney, and a medical power of attorney, about $1,500 per person. If you go downtown to a very large firm, you'd be looking, it could be anywhere on up, because their prices are going to be geared for very wealthy individuals. And you want to try to stay out of either boutique firms that are really designed for super rich people, if you're not super rich. If you're really rich, if you're really wealthy, and the decisions they make could save you, tens of thousands, if not $1 million in taxes, then you do really want to go to a super expensive place. But be wary of boutique firms, little firms that are specialized in trust and estates, or
Yeah, you're fine. Sit down.
oh,
What,
sorry,
what did he say?
what's that?
What did she say?
Oh, it was just someone who had their mic on.
Oh.
Yeah. So, and then are there resources online? So, for a very small estate, you can probably find an attorney who could do a power of attorney for say $250, $300, medical power of attorney anywhere from, I'll say for each of those documents, anywhere from $200 to $300, and then the will $500 to say $900. So it's a mix. It's a mix. And if you should, whenever you're looking for an attorney, if you're looking, what you should do is Google the county or the town you're in, the specialty of the attorney, look at their website, see how specialized they are based on their website. Pick 2 or 3 attorneys, call them, ask the price. That's always my bet, whether it's a criminal attorney, an estate attorney, whoever it is, a Medicaid attorney, you want to ask, those are some of the questions you want to ask and talk to them. And if you like them in their office, hire them. If you don't. So that's my suggestion. Now, what if you want to save money, limited means, there are wills that are online. There are resources where you can draft do-it-yourself wills. There are do-it-yourself powers of attorney. The power of attorney is a pretty standard document. So it's like, you don't need a special, like you could just pull one offline for the state you're in, you'll probably be fine. What you don't get, or medical power of attorney, same thing, you can appoint a healthcare person. But what you don't get is, for example, if you have a power of attorney, if you go to an attorney like me, you're gonna get, who is your first choice? Who's your second choice? Who's your third choice? What if your first choice can't act? So I like to make documents last a really long time. And the way you make them last a long time is you have fiduciaries, you have your first choice, your second choice, your third choice. And your third choice, if it's possible, should be in a younger generation. So you'll always have someone who's there for you. And then one of the things you get, oh, sorry.
That's okay. Just whenever you're ready. I have another couple questions.
Oh, okay. I'll just do one more comment about the specialized, the medical power of attorney. One of the things that I do that I just sort of figured out along the way is I have the decision to turn you to end of life decisions, the decision to withdraw medical treatment has to be made by the attending physician and your healthcare agent. Why? What I have 2 keys. I call it a 2-key system. Why have 2 keys? In my thinking, and my clients have really liked it, you want to have the emotional weight of ending the life of a loved one shared by a professional and your agent. You want it to be a joint decision. So that's why I do it. So you won't get that in a off-the-shelf medical power of attorney, that kind of thing. Okay, next question.
So another question. Thank you, Brian. Where do you get the separate HIPAA authorization form if not included in a healthcare POA?
This is one of the healthcare POA. I guess you would just Google.
Okay.
Google HIPAA.
All right.
HIPAA.
All right.
Yeah,
That's
HIPAA
great.
authorization. That's what I do.
Okay. And then the other question is, can there be more than one power of attorney? Can there be 2, 3, multiple? Like how many can there be? You mentioned that you and your brother were power of attorneys. Can there be 2?
Yes, you can appoint 2 agents. And there's 2 ways to do it. Either they can be co-powers of attorney, so they have to each sign it, two signatures on each check. And that's if you trust them, but you're not sure how much. Or you can have them, give them independent powers to act. And in my mother's case, she was an estate planning lawyer as well. And I was really, I influenced this. My brother and I get along really well. One of my brothers and we are the youngest of 4. So in that case, it was great to have 2 independent powers of attorney because you can share the load of taking care of someone.
Right.
So my brother wound up taking care of my mother's apartment, condo, rental, tenants, and I wound up dealing with things like hospitals, long-term care insurance, and that kind of thing. And we didn't need 2 signatures.
Right.
So 2 trusted people who work well together, you could do independence.
Great. Any other questions? I know that we're down to well, we have a couple of minutes. And are there any other questions in the room?
I do have a question.
Yeah.
What about special needs disabled people and power of attorney? Is there anything
Well,
in there?
the question about what about people with special needs and powers of attorney? So the power of attorney gives the person the power to take their existing assets and to deploy it for a nursing home, care facility, that kind of thing. It doesn't take the place of a special needs trust. So suppose someone has a sum of money and they're disabled and they're running out of money. What you can do with, say, your last $100,000 is you can create something called a self-settled special needs trust. And what's different about that is it has, just a lot of discretion. You need a limited discretion for your agent to make gifts, but if there's anything left over, it's their money. They're already on the dependent on welfare. Then they have to give what's left over to the Department of Welfare of the state. Okay, but the power of attorney doesn't take the place of like certain Medicaid planning techniques that could make it sure that some of their money could be used for things that Medicaid doesn't cover. So as you're on the descent and people are spending down their estate, at different stages, there are a few different strategies, not a whole lot, but a few different strategies. So there are two different documents you're talking about, but but one won't suffice.
Do you deal with special needs trusts
Yes.
yourself and special needs
I'm
power
not,
attorney?
an absolute maven in it, but I do it and do it well.
Okay.
Yeah. Other questions in the room? Anyone else?
I went through this business of not having the medical power of attorney with my father, but the hospital kept asking me for decisions. They won't give me records, but they would.
So someone in the room said my father didn't have a power of attorney, but they kept asking me to make decisions, but
Because
they
I was
wouldn't,
listed as his
they wouldn't let me
contact.
see his records or give me any information. Wow, okay. So
Well, it's in
here-
California, so it's.
well, that's enough, yeah. So here's what happens. There's like the law as it's designed, and then there's reality. So the reality is when my dad was in Graduate Hospital downtown, and he was in one of his many visits to the hospital, and he was fighting a flu, and he was very in decline in cardiovascular disease. The doctor came out in the hallway. He didn't ask for power of attorney. He asked whoever shows up. This is why the least important document is the medical power of attorney, but it's still useful. Okay, he just turns to what's called the next of kin. They don't have a duty. They don't just ask someone on the street, but if someone cares enough to be there, the doctor doesn't want to make some decisions themselves, right? So in that case, the question was, do we want to intubate my father so we give him a chance to fight the infection and pull the tube out 10 days later? This was a weighty decision. And I pulled the power of attorney out of out in front of us. And my mom and I both looked at it, and it pretty much said that he wanted to withdraw if he was on his last illness, but we didn't know if it was his last illness. So what are you gonna do? And my mother was just not ready to let him go. So gave permission to intubate. He had a tube in for, I guess, a week, and then they pulled it out. But the irony is that they wouldn't give you information because you weren't listed as the healthcare agent, yet they're asking you as an next of kin to make decisions. That's rare. In most cases, the doctor will say, okay, they just disregard all of those rules in a lot of ways. And they just say, look, you're the next of kin. This is what we're facing. These are the risks. If we do the procedure, this is going to happen. We don't do the procedure, this is going to happen. We don't know for sure what the outcome is going to be. What do you want us to do? So, I mean, it's a blessing they do that, but they really should have shared as much information as.
Well,
you
I
needed.
actually wasn't the next of kin, I was his contact, because my loopy mother was
Was the next of kin.
was the next of kin.
Yeah.
That's why he put, the reason I asked you this question is because right as this was happening, I was diagnosed with something that I wasn't sure it's genetic or not. And I wanted to figure out whether I'm gonna pass it to my son or not.
Yeah.
So I needed to get that information from the doctors, but they won't give it to me. Or they would say, well, yeah, don't worry about it. So is there a way to get around it?
Yeah, you can petition the court and you can ask them, say, look, this is why I want it. And
So as
No
now
problem.
that he died, turns out he made me the executrix of his estate. Does that give me the right to do that?
100%, as executor of his estate, you have the power to, right, you stand in his shoes. So any power he has to his own records, theoretically, you have the same power. Right? They're gonna ask you for letters of appointment and that sort of thing. They might give you a little bit of a couple hoops to get through, but you should have access. Yeah, good thing.
Great. Any other questions? we're down to the end, and I just want to make sure everybody has asked their questions. I don't think there's any other questions. I don't have any other ones in the chat, Brian.
Right.
Any other
No,
ones in the room?
What, someone else knew? Yes,
So just out of curiosity, I have parents in 3 different states.
yeah.
So, yes,
Someone in the room has parents in 3 different states?
yes. So-
Okay,
So basically, is all this gonna work the same universally from state to state? You left at California, so I'm just curious. I have Arizona, Pennsylvania, and Arkansas, so if everyone signs the exact same document that you get off of Google or goes to the lawyers and all that, are you all the same? And if I say, okay, I'm a power of attorney in Arkansas, power of attorney in PA, is there any differences in state to state? I'm not asking to know Arkansas, I'm just curious, or is it all pretty much
It's a
uniform?
great question, and the answer is that the basics of the law are the same in every state. Cause it's like the law evolves similarly, you know. The medical power of attorneys was a creature of law that came into force maybe in the 1980s or early 90s. But I'm sure it happened in every other state, because once one state does it, they say, well, that's a really good tool. We want
Then they
that too."
copy it.
Yeah, so it's gonna be similar, it won't be exact. The formalities of signing it, do you need 1 witness, 2 witnesses, do you need a notary? Pennsylvania's become really strict, you need 2 witnesses and a notary for power of attorney and a healthcare power of attorney, but you don't need any witnesses for a valid will in Pennsylvania. So, so that's an interesting, I mean, so the answer is, wherever the person is sitting, they have to have the will or power of attorney executed according to the law of where they are. That's who has jurisdiction, where they reside.
Right, my curiosity is that if, let's just say I'm the power of attorney in all 3, right?
Yeah.
That when I go in PA and I go through all the rules and all the stuff, is it gonna be, you know, in theory, it should be the same when I do it in Arizona and when I do it in.
Similar, can't guarantee it's the
Very
same.
good. That's
I
it.
actually I'm going through that right now, and my father was a resident of Pennsylvania, my mother was resident of California, my dad was living in California. I live in Pennsylvania, I have to get a power of attorney that is covering both states, it's 36 pages. I went from 3 pages in California to 36 pages,
It doesn't have to be.
because it has to, but apparently, I'm dealing with lawyers on both sides, apparently it has to do with the fact that there are some weird things that Pennsylvania requires that California doesn't, so the 2 attorneys have to work out this
So
this
the real
comment, and it
answer,
actually says, like, you know, that opening statement, it says in California and Pennsylvania.
so there's 2 different answers. The legal answer is, there's something in the Constitution called the full faith and credit clause. And it says,
What's it called?
full faith and credit clause, and it says that things like wills, power of attorneys in any state are to be recognized in any other state as long as they were valid in the state where they were created. Right?
The banks are not
Hang on.
accepting that.
But there's a second test. What are banks familiar with? What are they comfortable doing? Banks have a problem, and the problem is that if they give money to the wrong person, and then the right person shows up a year later, they have to give the money again. Right? So if you drain an account of $1 million, they're like, oh my God, we're out of $1 million. So they're very uptight about these documents, and they have good reason to be. So they generally will only accept the documents in their own state, or maybe a neighboring state they're pretty familiar. And they'll have the legal department review the language, but it's best to make banks happy. Ultimately, you want the document recognized by banks, where your parents bank. So you might want to call them and say, what do you want?
I actually, Wells Fargo is in both states, and I have to get a power of attorney in Pennsylvania and in California.
Never heard that happening before, but I believe you. It wouldn't hurt, other than it hurts your wallet a little bit. Okay, but it's the least expensive, the documents, because they're automatic, all those pages are automatic, they don't redraft them very much. They're not very customized.
so we
All right.
have one more question.
One more question.
Yeah, one more question. Does a will need to be registered or notarized in PA?
No, a will does not need to be, first of all, you can't register a will with the register of wills until someone dies, they just won't take it. Secondly, a will can be signed by the testator themselves. And it does, you don't even need a witness as long as after the fact, you have two witnesses who are familiar with the person's signature, and then they go into the register, will say, I know that person's signature, that's their signature. The problem is that if you have a situation where relatives are at odds and are fighting and are gonna challenge, if there's a risk of challenge to the will, you really want to have an attorney do this if possible. If you have time permitting, medical conditions permitting, you want to have a lawyer help the person out and then have a formal signing with
Right,
with
it's like a
witnesses.
mediator. It just takes the pressure off one of the other.
It's not that, but you want formal signing so that we'll get into probate.
Right.
You need two witnesses either before or after the person dies. So if it's before the person dies in a special attestation page, then it goes right into probate. It's less of a challenge. And if you have two witnesses who sign right there, they could say, I saw him sign it. We had a conversation beforehand. We
Right.
talked about Phillies. He talked about how much he didn't like, this politician, that politician. So they can attest to capacity, right? So if you have a contest coming, you really want to do it the right way. But if you have someone on their deathbed and there's no problem having a handwritten will. I had an estate that was worth over $1 million, and the wife did not like the big long will, and she wrote a 1-paragraph will, and that was enough to probate her estate. And then after she died, we did something, a fancy thing called a disclaimer, and we saved her like $300,000 in taxes. So you could have a 1-paragraph will, as long as no one can test it, you're fine.
Right. Well,
Yeah.
thank you so much. I know that we're at our time, and I want to be respectful of everybody's time online, and also want to say thank you to Pam. Thank you so much for allowing us to collaborate with you. PMC really enjoys our relationship, and we will have more workshops in the future. I did get one of the questions wanting to know if they could suggest a topic. So Pam, you'll be getting an email or something from someone.
Okay,
And
good.
then
Always use
and-
suggestions.
oh, great, wonderful. And then
I'm
Brian,
putting on the
thank you
screen
so
the
much.
resources. Oh,
Thank
you're
you for your
welcome.
time. I'm
Yeah,
sorry.
I just wanted to put up resources that you have here. And you can see there's a living will, advanced directive. Let's see, and a couple of other documents. So
Yes.
this is to you, so you can follow up.
And I'm gonna email all this.
Yeah,
Yeah. And I'll also email you the link so you can actually watch this.
And Michelle, thank you. It's always fun. And
We
it
appreciate your
reminds-
time, Brian.
thank you.
Yes, thank
You're
you
welcome.
very much.
Bye, everybody. Have a good evening. Have a good
Thank you.
holiday.
Thank you very much. Thank you. Bye-bye.
Bye-bye.
Good night, everyone. Thank you.
Good night.
Good night, thank you.
Thank you.
I have another question related to me.
Sure. If anyone wants to keep going, you can either stay around the table or go ahead.
I'm trying to get the money out of TIA and not TIA, I think it's BNY. They want me to have a medallion.
Yeah.
And apparently it's very hard to find. Is it something you should have ahead of time, or it's something you have to
Now,
have?
they're gonna give you a document. A medallion is a special program. It's like a super notary where they know. And the only person that can give a medallion is either financial institution or your own bank where you have an account. And it's like an extra service if you don't have any bank account, you have good luck in getting a medallion. You have to go to your own bank, call in advance. You have to get someone especially appointed to be that person. And the bank is pretty much saying, I guarantee that this is the right person. And this person is, as the one who signed this document. Because if the bank's wrong, you take on personal liability for that. So they want to know you are you. So banks often, they don't do a medallion guarantee unless you have an account with their bank, because what's the point? It's not even worth it.
Well, the interesting thing is that I went to a bank. They said one branch can do this much, this branch can do another amount. But is that the amount of money in the bank is mine? They're looking at my amount of money or my parents? Because my father left a lot more money than I have.
You're going beyond my knowledge of medallion guarantees. Just ask
Who
questions.
do I talk to about this?
The bank,
Just,
just talk to them. Say, how does this thing work?
Yeah, one bank scratched their heads.
Go online,
Okay.
Wikipedia, wherever, you know, if you just go in Google and you type your question. Someone taught me years ago that if you go into Google and if you have a legal question, be as precise as